webinar series. What ERAs need to know in 2025 and why AML is on the radar is our topic for today's discussion. First, I'm going to describe the webinar format, get into the agenda, introduce our speakers, and then we'll get into it. So first and foremost, the SALIS GRC Navigator series is our webinar format where we're presenting up-to-date regulatory topics of interest to our audience. Today's webinar, as I mentioned, is on the topic of ERAs, exempt reporting advisors. And the way that our webinar format works, you'll see there's a chat feature. If at any point during this webinar you have questions, comments, if you'd like to ask the panelists, please pose your questions in the chat. There will also be polling questions asked throughout this webinar, which will help us sort of tailor the presentation to our audience and also, again, give you a sense of what your peers are going through and how they're approaching this particular topic of interest. The exempt reporting advisor portion of the industry is a very important segment that we'll get into, and AML obviously is a very new rule that investment advisors will need to comply with by January 1st. Going to read a disclaimer here. The views and opinions that are expressed in this webinar are those of the speakers. They do not necessarily reflect the official policy or position or of their respective organizations or any of their affiliates. This presentation is for informational purposes only and should not be considered legal, financial, or regulatory advice. Additionally, no part of this webinar constitutes a recommendation or endorsement of any particular product, service, strategy. Please consult your own advisors, counsel, regulatory compliance consultants, and so forth for recommendations specific to your firm and your profile. That being said, I'll give a quick bio of myself here. EJ Yurzak, I'm a managing director at SALIS GRC. I have 2 decades of regulatory compliance and cybersecurity experience involved with exempt reporting advisors, as well as registered investment advisors of all shapes and sizes, wealth management firms, private equity, hedge fund, you name it, real estate advisors. Very excited to be joined by David Dickstein, a partner at Catton. David, if you wouldn't mind sharing with our audience a little bit about yourself and your background and your bio. And again, very happy you can join us today.
Thank you, EJ. I'm happy to join as well. I'm a partner in the law firm of Catton, Meacham, Rosenman, in the New York office of Catton, Meacham, Rosenman. I'm in their investment management group. I've been practicing in this area for over 25 years, and I advise all sorts of managers on regulatory and compliance issues. They could be hedge fund managers, venture capital managers, registered fund managers, separate account managers, about regulatory issues facing them.
Excellent. Certainly a wealth of experience and knowledge, David. So again, really pleased that you're able to join us here and share your knowledge with our attendees. That being said, let's dive right in. First of all, the agenda for today, we're going to be covering what is an exempt reporting advisor, what is an ERA. Very important concept to understand, and there are some nuances that we'll dissect and break apart for you. We'll talk about the rules and regulations that are applicable to ERAs, as well as some considerations that are not applicable to ERAs. Again, the distinction is important, and as you're building a compliance program, these are things that are important to keep in mind. We'll talk about some of the reporting requirements, filing and disclosure, and so forth, as well as some considerations for firms that are planning to transition from an ERA status to full-fledged registration with the SEC or with a state. We'll talk about the AML requirements. So we'll segue from a full discussion of exempt reporting advisors into a discussion of the AML rule, which is applicable to ERAs as well as other advisors. And we'll conclude with best practices, common pitfalls, and a discussion of key takeaways. The gist of this discussion in this webinar is really to provide you with practical, tangible, business-centric advice. Obviously, if you have any particular questions or considerations relating to your firm in particular, please feel free to reach out to David or myself or anyone on our respective teams after this presentation. Be more than happy to have a conversation with you and discuss your particular needs. That being said, David, let's dive right in. If you wouldn't mind sharing with our audience here, what is an SEC exempt reporting advisor? What do we mean when we talk about an ERA? What does this concept mean?
Yeah, it's a little bit murky, the concept. It is important to understand that it is an exemption from full registration with the SEC, which means that you're not completely, there's some investment advisors that don't have to register at all, and there's some advisors that need to register with the SEC. And then there's this middle category called exempt reporting advisors that need to make some filings with the SEC, are subject a little to some SEC regulation that we'll talk about in today's webinar, but they're not fully registered and not subject to all the requirements of a registered investment advisor. It's important to understand that it's an exemption from full registration. In other words, the entity would be obligated to register fully as an investment advisor, but they're able to take advantage of this exemption. That's important because you can't just voluntarily file as an exempt reporting advisor. Even if you're not eligible to register as a fully registered investment advisor, you can't voluntarily file as an exempt reporting advisor. This came up for me once with a client that was an exempt reporting advisor because they were able to rely on an exemption from full registration. But then their business changed and they were no longer eligible to be a fully registered investment advisor. And they wanted to maintain and stay. They wanted to continue to be an exempt reporting advisor because they thought that was good for business practices, that was good for marketing, that they could say that they're an exempt reporting advisor that files with the SEC. And we had to tell them that was not the case. They could not remain an exempt reporting advisor if they weren't relying, if they weren't required to be a registered investment advisor that now was relying on an exemption. That was clarified by the SEC in 2023 in an FAQ that we have at the bottom of this slide, that in order to be able to be an exempt reporting advisor, you need to be first required to be registered with the SEC, and then check if you have some kind of exemption that can throw you into that middle category of exempt reporting advisor. So the first step to look at this is who needs to be registered with the SEC, because if you're not required to be registered with the SEC, this whole discussion doesn't begin. So any investment advisor with over $100 million in assets under management located in the United States needs to be registered with the SEC. Then there's a middle category called mid-sized advisors that if they have between 25 million and 100 million, they also need to be registered with the SEC if they are not required to be registered with a state, or if they're not subject to state inspections. So for instance, in New York, all advisors, you could be an advisor in New York that's required to register with New York, but if you have more than 25 million, but New York does not inspect investment advisors. As a result, any New York-based investment advisor that has more than $25 million under management automatically needs to register with the SEC because they're not subject to state inspections. And once you register with the SEC, you're no longer required to register, as an aside, no longer required to register with the state. It's either the state or federally. Other types of investment advisors that need to register with the SEC, if you would be or allowed to register with the SEC, if you are a multi-state advisor, which means that you would need to register in more than 15 states, the SEC has said, oh, we don't want to put that burden on you. They have to register with so many states. You can just register with us as well. Or if you're an advisor that's related to an investment advisor that's registered with the SEC affiliated, and you share an office with that advisor, even though you yourself are not eligible to be registered, but if your affiliate is registered, you can be registered as well. But if you're just an advisor with less than $25 million under management, you're not required. You're not in more than 15 states. You don't have a related advisor. You're not required to be registered with the SEC. And if you're not required to be registered with the SEC, ERA doesn't apply to you. But let's assume you fall into one of these categories. So you are required to be registered with the SEC, but you don't want to be registered with the SEC. It's too burdensome. It's too much work, too many requirements. And there are a lot of requirements if you're fully registered. So is there any exemption that I can take advantage of? That's where exempt reporting advisor comes in. And there are two types of exempt reporting advisors. One is a private fund exempt advisor, that's the private fund exemption that we have on top. That means that you can only have clients that are funds, private funds, that rely on either 3C1 or 3C7 exemptions from registration under the Investment Company Act of 1940. So those are basically privately offered investment funds that have either less than 100 investors or if they have more than 100 investors, all the investors are very, very, very high net worth, like more than $5 million in investments. So if your clients are exclusively those types of clients, no managed accounts, no separately managed accounts, no corporations, but they all have to be, the clients have to be these funds. You can have investors in those funds, but the clients themselves have to be these private investment funds. And you have less than $150 million in those funds combined, you can file as an exempt reporting advisor. And you can wait until you don't have to file as an exempt reporting advisor until you're required to, until 60 days after you're required to file as an exempt reporting advisor. So let's take an example. Let's say you're an advisor that has only private funds as clients, and you're a startup advisor, and you had $21 million under management last year. Now suddenly you got a new investor offers to come in, and they're going to put $10 million into your funds. You're going to now be over $25 million. You're based in New York. New York, there's no exemption. There's no state inspection program. So that automatically requires you to either file with the SEC as an investment advisor, registered investment advisor, or if you want to, you could take in that $10 million investment and file as an exempt reporting advisor with the SEC within 60 days of taking in that $10 million investment. And then you can stay as an exempt reporting advisor until your funds cross over $150 million. So you have another $120 million to go, which is it gives you a great leeway and a great runway to get used to SEC regulation in a light touch. The other type of exempt reporting advisor is a venture capital fund advisor. That means an advisor that only advises venture capital funds, which means a venture capital fund is a fund that at least 80% of their assets are invested in cash equivalents, and venture capital and qualifying investments. Qualifying investments are venture capital investments, so they're equity investments of private equity investments in private companies that are not borrowing money in conjunction with those with the money that your fund is putting into them. You have to hold yourself out as basically investing. The fund has to hold itself out in its documents as investing only in venture capital type investments. And it's got very strong limitations on how much the fund itself can borrow, no more than 15% of its total capital. If you meet those requirements, you can rely on the venture capital exemption. The big difference between the venture capital exemption and the first one is capped at $150 million. The second one, if all you have are venture capital funds, you can have an unlimited amount of assets under management in your venture capital funds. You're not capped at $150 million under management. And next, EJ, do you have anything you wanted to add there?
Yeah, I think this is a good segue into our next slide here. I mean, this concept of exempt reporting advisors, it's not a get out of jail free card to just not have to comply with regulations. It serves a very important purpose within the investment advisor industry. And to your point, firms need to ensure that they're with the SEC, but for the existence of these exemptions. And so I think you did a great job explaining sort of where these concepts fit within the regulatory framework. And this concept of registration with the SEC for private fund advisors, for example, is a relatively new concept. We're only going 12, 13 years in terms of this requirement for private fund advisors to actually have to register with the SEC. So this concept of an exempt reporting advisor, an ERA, it's a fairly new concept, right, David? I mean, this concept didn't exist 20 years ago. This is a new
That's right.
concept.
That's correct. It's only started in 2010.
That's correct. And so a question for you, David, is in your opinion, why do you think the SEC created this additional category, this ERA concept? They could have simply said, look, if you're over 150 million, you have to register. If you're below that, you don't have to register with the SEC, or you have to register with the state. But
why do you think what happened was prior to 2010, the SEC had an exemption if you had 15 or less, an investment advisor that had 15 or less clients and didn't publicly hold itself out as an investment advisor, needed to be registered, had an exemption from registration with the SEC. The Congress eliminated that exemption. The reason why they eliminated that exemption is was because you could have these huge money managers with all they had were funds, and the funds were considered the clients. The funds had hundreds or thousands of investors in them, but they just had two funds as clients, and they could have literally billions of dollars under management, and they weren't subject to SEC oversight because they only had two clients, the two funds, less than 15. Congress eliminated that loophole because they wanted to be able for the SEC to be able to oversee even advisors solely to funds. But at the same time, they realized that for advisors who just have smaller funds, that SEC regulation would just be too much. So they created this middle category that entitled you, as long as you have less than 150 million, or you're just a venture capital fund, which was not what the SEC was mostly concerned about, or Congress was mostly concerned about, that you can remain in this sort of registration light mode and not be subject to the full registration. But they did that as an accommodation when they wanted to basically take over regulation of all the larger fund advisors.
So this is sort of a way for the SEC to gather more information about the investment advisor industry in terms of a limited set of disclosure and perhaps a more limited set of compliance obligations without completely taking their eyes off of this category of investment advisors, this category of ERAs. As we have on the screen here, this notion of SEC registered advisors, full registration versus ERAs, a more limited scope here. This distinction is important because registered investment advisors, those who are fully registered, have to fully comply with the Investment Advisors Act and all of the rules and regulations promulgated thereunder. This includes, at the outset, filing the Form ADV, including all parts of the Form ADV that are applicable. The Form ADV Part 1A, which is the objective set of disclosure, the Form ADV Part 2A, which is the narrative brochure format, explain the information about the firm and its business and its client composition, assets under management, applicable risks, and things like that are in the Part 2. If you're an exempt reporting advisor, it's a limited set of disclosure. It's the Part 1A, but not necessarily the Part 2A. So right at the outset, there's a distinction in terms of what you have to file with the SEC to claim this exemption, to initially take advantage of this ERA status. Following that, we talk about policies and procedures, and that's another area where ERAs are distinct from full-fledged SEC registered advisors. If you're an ERA, and we'll get into this in subsequent slides, ERAs need to comply with a limited set of the Investment Advisors Act, a limited set of rules and regulations, whereas SEC registered advisors have to comply with custody rules. They have to comply with fully rolling out compliance programs, designating a chief compliance officer, a full-blown code of ethics in compliance with the code of ethics rule. And again, we'll talk about this in some of the subsequent slides here to break this down in more detail. But keep in mind that ERAs is really a lighter regulatory framework that's applied to this subset of advisors. So David, on the next slide here, we have this concept of a state ERA. We've been talking about ERAs at the federal level as well as the state level. I just sort of broke down the distinction between a SEC registered advisor and an ERA from an SEC federal perspective. But what about at the state level? Do states have this exempt reporting advisor concept as well, or is this strictly a federal concept?
Some states do, not all states. But some states definitely have them. California, Texas, a few other states. That if the states usually have a test. If you have a place of business if you're an advisor that has a place of business in the state, or more than 5 clients in the state, you need to be registered with the state. Now, some states have carved out that if all of your clients are funds, like the SEC exemption, you do not need to be registered with the state, as long as you file that ADV Part 1A with the SEC, with the state, instead of with the SEC. So there certainly are, and so in other words, let's say you have 3 clients, but all of them are funds in certain states, that would not trigger, and you have a place of business in the state, that would not trigger, well, let's say it's a state that doesn't, let's say it's a state where you don't have a place of business in the state, but you have 3 clients in the state, but all of them are funds. It would not necessarily trigger registration. Or you have a place of business in the state, but the SEC gives you an exemption if your only clients are these funds. There also could be a situation where you need to do both with the state and the SEC exempt reporting advisor. That would be a situation where if you have more than $100 million under management, states cannot regulate you. But if you have between 25 and 100 million under management, and you're exempt from the state registration because of the state ERA, you're also going to need to file with the SEC. It's the same filing. You just check the box and you file it. You're filing with both places. But the reason why you need to do that is because once you have more than $25 million, if you're not registered with the state because you're relying on an exemption, then you automatically need to register with the SEC unless you have an exemption there. So in that situation, you'd be duly filed as an exempt reporting advisor, both with the state and with the and federally with the SEC. But if you have less than 25 million, you still could only be, there are situations in certain states where you would if you wanted to avoid SEC state registration, you would file as an ERA solely with the state.
Okay, so it's certainly a state-by-state analysis. As you mentioned, David, not all states have this ERA regime in place, but it is important to do a state-by-state analysis. And if you have questions, consult with counsel. Folks like David can walk you through that process, analyzing what's applicable to your firm. These exemptions are important to keep in mind in making sure that you're adhering to the exemptions strictly that are applicable, because as we'll get into in subsequent slides, the failure to appropriately claim the exemption or claim an exemption that you're not eligible to claim is ripe for enforcement and other deficiencies.
I just want to add one thing.
You were going to say something?
Yeah, I'm sorry. I just want to add one thing. There are some states that the requirements are actually more restrictive than the SEC. So with the SEC, as you said before, and we're going to cover later on, there's certain rules you have to comply with. You have to file the ADV. But in certain states, if you have certain types of funds, like 3C1 funds, which are funds that are not super duper wealthy people in the funds, and as long as you have less than 100 investors in the funds, they may require you to send audited financial statements to the investors in the funds under the state rule. They may require the clients, the investors in the funds, to meet certain eligibility requirements before you charge a performance fee. So sometimes the state exemptions are a little bit more restrictive than the SEC's exemption.
It's a very good point. I'm glad you clarified that. Just don't think that because you're claiming at the state level that you're going to get a pass on some onerous regulations. I want to take a moment and note that we are continuing to receive some questions in the chat. We'll try to get to as many as we can during this presentation and at the conclusion of the presentation. So I certainly want to encourage folks that, look, if you have questions about anything that we're discussing today, please pose your question in the chat. If there are any questions that we cannot get to during the course of this webinar, we'll certainly follow up thereafter. Want to make sure that your questions are being answered. So yeah, please feel free to reach out. Jumping to the next slide here, ERA exemptions. David did a great job explaining some of these concepts, so we're not going to spend a ton of time on this slide, but one of the things I wanted to really highlight here is this concept of full registration versus not. ERAs are not registered with the SEC, and I know that sometimes the terminology gets lost. I've heard folks say, well, what do we need to do to register as an ERA? And so I want to make that point clear that registering with the SEC makes you a registered investment advisor. Exempt reporting advisors are eligible for registration, but exempt from registration. And so it's a very important concept. But again, it's something that I often hear used interchangeably, and that's not completely accurate. ERAs, as I mentioned, they must file certain information. It's applicable to private fund advisors. One of the very important distinctions is that ERAs technically do not need to appoint a chief compliance officer. This may surprise some. Many ERAs do, in fact, name a CCO or name someone who is serving in that function because there are some compliance obligations. But again, until you're fully registered with the SEC, there is no specific requirement to designate a chief compliance officer. Rule 206.47, the compliance program rule, requires the designation of a chief compliance officer for registered investment advisors. Again, David talked about some of these exemptions. The 80-20 rule is, again, another important characteristic of the VC exemption. So again, keep that in mind. It's not to say that any venture capital fund advisor can claim status as an ERA. You really need to comply with that 80-20 rule if taking advantage of that exemption. Again, the ERA concept applies to advisors solely managing private funds. So again, if you are managing private fund clients and you take on some separately managed account clients, or you sort of evolve your business practices to increase your client mix and composition, this could void your exemption. And again, we'll talk about what this transition may look like if you no longer are eligible to claim this exemption, what you need to do. Final point I'll mention on this slide is this notion of exempt. It does not mean exemption from everything. It does not mean that as an ERA, you're exempt from complying with everything. It simply means that you are claiming this exempt status is a lighter regulatory touch. You are exempt from some of the regulatory requirements, but not all. You are, for example, you remain subject to SEC oversight. However, you're not likely to be subject to routine SEC examinations. So SEC examinations are done with registered investment advisors. However, if you violate any of the rules that are applicable, you can be subject to enforcement, but not regular examinations. Now we have a polling question here. As we get into our next slide, I'll just read the question. How does your firm primarily ensure ongoing compliance with SEC, ERA or state ERA obligations, including keeping abreast of new requirements? Do you tend to work with outside counsel? Do you tend to do internal research, conferences, other? Please let us know in your response. Again, we're going to have a few polling questions here just to keep everybody engaged, but also to inform where we go with this conversation. So it's certainly helpful for our purposes. David, I know you mentioned that you work with a lot of advisors who are exempt reporting advisors, fully registered advisors. What is the number one question? I don't mean to put you on the spot here, but what is the number one question that an ERA will come to you with? Is it about, hey, am I eligible for this exemption, or are they asking you broader questions?
Well, I guess that's breaking them down two ways. Advisors that are not registered as ERAs or filed as ERAs yet, they'll want to know if they're eligible for it. That's probably a big question, and when they're eligible to take advantage of it. Once they are an ERA, I would say the biggest questions that come up actually are related to their ADV annual amendment, which we're going to talk about, I think, in the next slide. But
yes.
Questions that come up related to the ADV, because that is a filing that they have to make once a year.
Yeah, absolutely. I think the ADV distinction that we mentioned, the Part 1A applicable to ERAs, and then the Part 2 that firms that are fully registered have to comply with as well. So let's take a look at the responses here. I think we're still waiting on some answers here. Okay, so David, let's continue on with the presentation here. We talked about some of these reporting requirements for ERAs. I mentioned the Part 1, for example, no 2A, no 2B, no Form CRS. That's a wealth management consideration for individual clients. What are some of the other considerations that ERAs have to comply with? I know it's a limited set, but it's not a null set.
Yeah, so first of all, even the ADV Part 1A is not a full ADV Part 1A. It's not as if you see here on the side here, this slide, those are the sections of the ADV Part 1A that you need to comply with. As you see, some numbers are skipped, like item 5, item 9. Those are very detailed. Item 5 is very detailed questions about your business. Don't have to do that for an ERA. Item 9 is questions about custody. The custody rule doesn't apply to an ERA. So there are some, even within the ADV Part 1A, there are some relief from some of the things that a registered investment advisor needs to do. And an ERA needs an exempt reporting advisor needs to file that form once a year. And it's one of the things that's most important when it comes to filing that form, which I think we're going to talk about a little bit later, is have you crossed over? Do you have more than $150 million under management? Because if you crossed over, then you're going to have to transition to full registration shortly thereafter. So there's the annual amendment. Assuming you haven't crossed over and you're continuing to be as an ERA, you have to update your information about the funds that are listed there. ERAs usually list funds and give detailed information about their funds on the Form ADV. That's in item 7B and Schedule D related to 7B, where you have to provide detailed information about the investment funds that you advise. Besides the annual amendment, there could be an other than annual amendment, where if there's a change in ownership structure to the advisor, there have been legal proceedings against the advisor, disciplinary actions about the advisor, that would trigger an other than annual amendment. And then there, as we will get into, under AML rules, there are AML reporting requirements for exempt reporting advisors, suspicious activity reports, transaction reports, cash transaction reports. There's also Section 13 reporting, which is, I think we're going to cover, this is going to be covered on another slide as well, but if you're an exempt reporting advisor, you could still be subject to Section 13 reporting under the Securities Act of 1934, which relates to if you own more than $100 million of certain types of securities listed by the SEC, you have to file something called a 13F with the SEC periodically. If you are a large trader, which means you trade more than $20 million in a month, or more than, in a day, or $200 million in a month, or more than a certain amount of shares, 2 million shares or 20 million shares, you need to file something called a 13H. All those Form 13 reporting requirements would apply to an exempt reporting advisor, in addition to the ADV requirements and the AML requirements.
So David, you mentioned an important concept here, and it's the transition from ERA to full registration, which we're going to cover on this next slide here. Oftentimes, this transition happens based on assets under management, and it can happen both directions. An increase in assets under management, using the example that you gave earlier, David, where an investment advisor may take on an additional client that puts you over that threshold. You would need to fully register with the SEC. Conversely, if you fall below a certain threshold, if you lose assets, this could impact your eligibility and your status as well from this ERA process. And so when we talk about transition, it's usually triggered by a change in AUM. It could be triggered by other changes in the business, but AUM is typically the number one factor that's going to impact this. First and foremost, as David mentioned, it's a change to the ADV. Firms need to file a final report on their ADV. They need to submit a final ERA filing. That informs the SEC that you're done. You're no longer claiming this ERA exemption. You're done with that status, and you're moving towards full registration, if that's the approach that you're taking. Once you're moving in that direction, you need to file a full ADV. The Part 1 to Part 2A, you need to fully comply with the SEC disclosure requirements. You also need to make sure that you have a compliance manual that complies with full-blown SEC registration. This includes the custody rule. This includes the code of ethics. AML, obviously, ERAs already have to comply with, or they're going to have to comply with starting January 1st. But there are some rules and regulations that are going to be additional to those that were applicable to you as an ERA. And so when you make that switch, when you make that transition filing to go from ERA to fully registered SEC advisor, it's important to make sure that you have your policies in place. It's important to make sure that you are taking the time to understand what are the additional applicable regulatory requirements. You're going to need to designate a chief compliance officer. That is no longer going to be a best practice or a nice to have. It is going to be a regulatory requirement. You're going to have to develop compliance policies and procedures that are appropriately tailored to your firm. A compliance manual that's applicable to a fully registered advisor. As we'll get into later on in terms of best practices, take the time to understand what those additional requirements are. It is not a small list. There are certainly some things that are difficult to document in a procedure until you get the operations aspect down first. David, one of the questions I have for you here, just because I've seen this in practice as well, when firms initially file as an ERA, I've seen some firms file as an ERA and they have a compliance manual that is designed specifically for an ERA, and it is only describing those policies and procedures applicable to an ERA. But I'm also seeing a decent number of ERAs initially start off their ERA process by having a compliance manual that is as if they were fully registered, meaning they have a full set of compliance policies and procedures. I've spoken with a number of these firms. They're going in that direction because they intend to fully register within a matter of a few months. And they don't want to have to adopt a compliance manual now and then substantially revise and revisit that compliance manual in 3 months or 4 or 5 months. They're also, the other reason that they've mentioned is that investors are expecting that they have controls around certain additional areas that a full-blown compliance manual for a fully registered SEC advisor would address. What are you seeing in practice? Do you tend to see more firms choose to file an ERA, file as an ERA with just the scope of policies and procedures applicable to them, or do you see them initially starting off with a full-blown compliance manual?
I see the former, that is usually the lighter compliance manual, not the full-blown compliance manual. There's nothing wrong with doing the full-blown compliance manual, but it comes with a very important caveat. If you've got the full-blown compliance manual, you've got to comply with your procedures and policies and procedures in there.
Absolutely.
And if you're not ready to do that yet, that could actually create many, many problems for you. I defended a client many years ago, not an exempt reporting advisor, that the entire case in front of the SEC was about that they said in their policies and procedures that they would ensure that they would do something, and they didn't ensure that they did it. And that was the topic. So if they weren't required to ensure that they were going to do it, but they said it in their manual that they would ensure they would do it. So if you take on something voluntarily, you got to make sure that you're able to do it. And so I think many clients prefer to keep on the lighter touch of regulation until they're getting very close to the registration thresholds.
That's great advice, David. I would say for our attendees here, if you only take one thing away from this presentation, take away that point, that if you hold yourself out as saying you're going to do something in your policies, you better be doing that, because that is what you're going to be held to. That is the standard that you'll be held to and measured against when the SEC comes knocking. So David, we talked about some of these concepts, but on this next slide here, these are some of the rules, right, that are going to be applicable to ERAs. These are non-negotiable. These are the rules that apply. What can you tell our attendees here about what's in scope for an ERA?
Yeah. So again, you don't have the full registration, you don't have the full regulation, but you do have these rules. Number one, all advisors, whether you're an ERA or not, is a fiduciary. What does a fiduciary mean? A fiduciary means you have a duty of care with respect to your client's assets. That means you need to use adequate care in managing your client's assets. You can't be negligent. You've got to be responsible with respect to the investments you're making for your clients. You need to understand, you need to be able to support what you're doing for your clients, the investments you're making, and you have a duty of loyalty, which means that if you have any type of conflict of interest, you need to disclose that to your clients so that they understand it. Even if you're an ERA, if you have any kind of conflict, you need to disclose that. One of the types of conflicts that comes up, which is actually mandated by the SEC, I'm skipping down a slide, a bullet point, is principal trading. A principal trade or agency cross transaction. A principal trade is where an advisor is either selling, an advisor or its affiliate is selling a security from its own account to a client account. That is a conflict of interest, or the other way, buying a security from a client account for its own account. That's a conflict because maybe you're going to take advantage of something for yourself vis-a-vis your client. So that rule actually requires that you get just a disclosure consent before the actual transaction. Agency cross transactions are similar in where you're facilitating a trade between two client accounts, but you're getting paid for it, for the facilitation of that trade in addition to your advisory fees. Again, you need to get consent to that before the transaction. But those are just two examples of conflicts of interest. There could be dozens of conflicts of interest. If you have a conflict of interest, under the fiduciary obligations, you need to disclose those conflicts to the investors, to the clients, so they understand what they are and they make a decision whether they want to hire you, even though you have that conflict. There's also anti-fraud requirements. All the anti-fraud rules under the Advisors Act apply to exempt reporting advisors. You can't do anything that would defraud your clients. There is a duty to supervise your employees. There are restrictions on political contributions. There's a very specific rule called the pay-to-play rule under the Advisors Act. That is a rule that applies to exempt reporting advisors. It basically puts limitations on how much money you can contribute to public pension plans if you're trying to seek business from those public pension plans or other government entities. So if you're trying to seek money, let's say from the Texas retirement plan, if you gave money to, if your employees, certain employees gave campaign contributions to people in Texas who can influence that decision, you may be limited from taking in that Texas retirement plan as an investor in your fund. The Advisors Act has a provision on insider trading, which says that every investment advisor needs to adopt policies and procedures to prevent the misuse of material non-public information. That applies to investment advisors, to ERAs. The AML requirements we're going to talk about in a slide or two. And then all the Section 13 requirements, which I spoke about earlier, those filing requirements apply to exempt reporting advisors. We talked about those earlier. And then whistleblower protections. There are certain anti-retaliation requirements imposed on investment advisors if their employees report them or non-compliance to certain government agencies. Those whistleblower protections apply to employees of exempt reporting advisors as well as fully registered investment advisors.
Right. So David, it's interesting when I look at this list and I see that insider trading rules are applicable to ERAs, but the Code of Ethics rule as a whole is not applicable to ERAs, meaning the requirement to for personal trading and the restrictions around personal trading, not specifically in scope for an ERA, yet you still can't do insider trading. So again, some important distinctions here. And I know it can be a little confusing to think, okay, well, how do I monitor for insider trading? How do I stop insider trading if I'm not looking at personal securities transaction reports? But again, just from a regulatory standpoint, this is an important distinction. What are some of the other rules that do not apply to an ERA? Again, I mentioned it's a lighter regulatory touch, but what are some of the other rules you think that may not apply to an ERA?
The marketing rule doesn't apply to an ERA, that's a very, very restrictive rule about how you market to investment advisors. The custody rule, right, which is a very restrictive rule, doesn't apply to ERAs. Again, with both of these, you can't do anything fraudulent, but the specific requirements of those rules don't apply.
Excellent point. Yeah. So the marketing and advertising rule doesn't apply, but notwithstanding that, you still can't be fraudulent in what you're saying and doing. All right, let's move on to the next slide here. Reporting and enforcement risk. So Dave, one of the concepts that we mentioned earlier is that ERAs are not subject to regular examinations by the SEC, but that doesn't mean that they're free from enforcement risk. It doesn't mean that they're, again, having a get out of jail free card to go and commit fraud or do anything that would ruffle the SEC's feathers and violate certain rules and regulations. That being said, the likelihood of enforcement for an ERA seems relatively low in terms of the risk profile. Is that your understanding as well? I mean, that's what I've seen, but it seems like the number of enforcement actions against ERAs few and far between.
Yeah, I mean, there have been a few. I'm not sure if the risk, if it's because of the risk. I don't think it's because the risk profile is lower. I mean, if they're engaging in fraud, they're ripe for an enforcement action. I think that's mostly a function of the fact that they're not subject to regular inspections, and as a result, the inspection staff of the SEC is sort of the eyes and ears of the enforcement staff, and a lot of enforcement matters are referred through the inspection staff. But if you're not subject to a regular inspection, then the SEC is not necessarily going to pick up on you. Having said that, if there's actual real fraud going on and somebody reports you and your customer reports you to your client reports you to the SEC, they're going to come in and they're going to bring an enforcement action against you, and they have done so.
Right. I think the areas in which I've seen enforcement or even just simply getting notification from the SEC are all based on the limited information that the SEC does have available about advisors. And it tends to be information that's on your ADV Part 1 filing or information that may be publicly available that the SEC happens to discover about your firm. But using the ADV as an example, the few items that I'm aware of where something has gone to enforcement or at least resulted in a letter from the SEC has to do with no longer being eligible for ERA status, having assets under management that are in excess of that ERA threshold, more than 150 million under management, or otherwise no longer meeting some of these exemptions and criteria. I've seen this in enforcement actions where some firms have tried to stay under the SEC's radar by having a combination of affiliates and partners that are each managing a certain amount of assets, but no one entity is managing in excess of 150. And the SEC has taken issue with some of these firms that through a network of affiliates are collectively operating as a single advisor that should, in fact, be registered with the SEC. But again, as David mentioned, for an issue like this to come to the attention of enforcement, the normal course of affairs for registered advisors, it would be through routine examinations, risk-based examinations, where some of these issues may surface for the first time. All right, we're going to pivot here a little bit. We talked about the AML rule as being one of the rules that's applicable to ERAs as well as registered investment advisors. So we're going to take some time here at the remaining time we have for this presentation and talk about this new AML rule. David, you can kick things off for us and sort of let us know what some of these requirements are, and then you can kick back to me and I'll talk about some of the latter components.
Yeah, so this is a new rule that goes into effect January 1st, 2026. It applies to registered investment advisors and to exempt reporting advisors. It's something that the federal government has tried numerous times to adopt, and they finally were successful during the Biden administration. We have received no indication that the Trump administration is going to cut this back, so we have to assume that it's going to be in place, new rule. And it requires that you establish an anti-money laundering program. It requires certain record-keeping requirements. It requires certain reporting requirements. And violations of it will subject you to penalties. I'll talk a little bit about the AML program, and I think EJ will talk a little bit about some of the reporting requirements and some of the testing requirements. But you have to have an AML program, which is an anti-money laundering program, which is designed to prevent anti-money laundering and financing of terrorist activities through your advisory firm. And that means that you have to have written policies and procedures that are based on the nature of your business, the nature of your types of clients that are risk-based to address anti-money laundering. Money laundering is where a bad player, a bad actor, is trying to take money that was obtained in a bad way, in an illegal way, and to cleanse it through either a bank, a broker, or now the SEC is concerned about through investment advisor accounts. And so they cleanse it through there so that it comes out. They got it bad, and then when it comes out of one of those accounts, now it looks like it's completely clean, like it was laundered. So that's what the SEC is trying to prevent. So you need to have every ERA needs to have, and every registered advisor needs to have an AML program reasonably designed to detect clients that are trying to conduct anti-money laundering through your business. You need, as part of that, you need to designate a chief AML officer or a committee that oversees that. Those people need to be qualified to oversee that program. They need to have the empowered to oversee that program. They need to be employees of the ERA or its affiliates. And you need to conduct customer due diligence of your clients to make sure to figure out what their risk profile is, whether they are a risk for conducting anti-money laundering through your business, or whether what their level of risk is. And depending on what their level of risk is, you need to adopt procedures to address that. You also need to adopt due diligence to monitor for suspicious transactions from your clients, from your customers, through your business, and on an ongoing basis, update your profile of each of your clients as to what their risk is for conducting these illegal anti-money laundering activities. You also need to train your investors, your employees, about how to detect money laundering, how to comply with the program that you put in place. There's and part of that same program is you need to do testing, which I think EJ will talk a little bit more about. And it needs to be, you do have the right to outsource some of these functions to others, but the advisor is required still to have the overall AML officer, and the advisor is required to oversee those vendors that they've outsourced some of these activities to make sure that they are doing an adequate job with whatever functions you've outsourced to them with respect to anti-money laundering. This is going to be a big lift for a lot of advisors in the next few months.
Yeah, the independent testing requirement in particular is an issue that a number of firms are outsourcing that function. They're choosing to keep the customer due diligence function in-house while outsourcing the independent testing, or perhaps they're outsourcing some assistance with the ongoing testing, monitoring, and then choosing to have an independent audit function or independent audit committee in-house that is conducting that independent testing component. The AML rule does allow firms to do it in-house or outsourced, with the exception that this independent testing has to be conducted by someone who is not responsible for oversight and administration of the AML program, or reporting to someone who is administering the AML program. Meaning, if the CCO is the one conducting the ongoing testing, customer due diligence, and so forth, that CCO, who may also be the AML officer, cannot be the one doing the independent testing. So what we're seeing in practice is that larger organizations, they may have an independent audit function in-house that is sufficiently independent from the AML program that is able to do it in-house. Smaller, mid-sized advisors, and particularly when we're talking about ERAs and that typical firm profile in terms of headcount and asset count, a lot of those organizations just don't have enough personnel in-house to be able to have someone who is not part of the AML administration of the program. We talked about suspicious activity reporting. Again, it's based on the risk profile. In context, you're going to have a series of transactions that look like they're designed to evade a $10,000 reporting limit and be structured in that sense. So maybe not as many suspicious transactions from that perspective as you would typically see on the wealth management side. But again, as David mentioned, part of the training has to do with being aware of and educating your employees about red flags of anti-money laundering, what these risks tend to look like, how money laundering tends to occur, the various ways that it can occur, and just being mindful of, if you see something suspicious, make sure that you're reporting that to the AML compliance officer so that if these need to be reported to FinCEN or other authorities, they can do so in a timely manner. Part of the independent testing is also designed to test whether or not suspicious activity reports were filed in a timely manner, as well as testing other aspects, policies, procedures, training, and so forth. We have a polling question here, and I'm going to jump to the next slide while we have this polling question. But has your firm reviewed its compliance policies in anticipation of this AML rule? We talked about this rule going into effect January 1st, 2026. It may seem like it's a long way off. Operationally, I can assure you it's not. There are a lot of aspects that need to be put into place before you're fully compliant with this rule. Policies, procedures is only one component of it, but from an operational perspective, making sure that you have these appropriate risk structures in place, reporting and governance structures in place to appropriately comply with the AML rule, that is typically going to take several months. I'm seeing firms start now with their AML process in anticipation of this January 1st compliance date. And again, to David's point, this is not a rule that we're seeing the current administration pull back from. So we're seeing some mix here. Some folks are have adopted policies already. Happy to see that some firms are starting the process. Unsurprisingly, we're still 8 months out. 75% of you have not started yet. I would say within the next 2 months, you certainly want to get started. You're probably looking at about a 6-month runway to put everything in place to be fully compliant. All right, so David, we just have a few slides left here as we approach the top of the hour. Best practices, common pitfalls. I know that one of the big ones that comes to mind is just monitoring your eligibility, right? Your status of an ERA and your AUM threshold. Just making sure that if you're getting close to that threshold, you're being prepared to take the next step, whether it's full registration or some other matter. Anything else that comes to your mind in terms of best practices, common pitfalls? I mean, we have a number listed on the slide here.
Yeah, I mean, I think it's important to have policies related to the requirements that are applicable to you. And you have to remember to update that ATV once a year. You can't just do it once and then forget about it.
Absolutely. It's an ongoing process. It's not set it and forget it. So it's, keeping tabs on your AUM threshold, making sure that you have the appropriate policies, training. You mentioned training, David, as part of AML, but training in general for compliance policies, obligations. There could be new rules and regulations. For example, folks that filed as an ERA a year ago, 2 years ago, again, if you're not paying attention to the regulatory environment, this AML rule might sneak up on you. You may not be aware that this new AML rule is out there and that it applies to you as an ERA. Okay, and finally, we're at our last polling question. How do you primarily manage your regulatory review? Policies, procedures, there's a lot to keep track of. And again, as folks answer this question, David, we'll jump to our last topic here, and that's, again, key takeaways. You mentioned policies, procedures, right? But not just having policies and procedures, the importance of tailoring those to your business. I know you mentioned that a lot of firms that you work with adopt policies and procedures specific to an ERA, lighter touch set of policies, procedures. Again, that helps limit the risk, right, of not having something in your manual that says you're doing something that you're not required to do and that you're not doing, right? And that's something that can get firms into hot water. Regulatory deadlines, I mentioned the AML rule can sneak up on you, but anything else folks should keep in mind as some final takeaways here?
I think we've covered that all. In addition to making sure your policies and procedures are updated, I agree with you that you should be testing them to make sure that they're working. And you should be training your employees because there are certain policies like that are very specific, such as the pay-to-play rule. So you got to make sure that you're compliant with those actual specific obligations.
Excellent. I know that we're at the top of the attempted to answer as many questions as we could that were coming into the chat. I know that there are a few questions that came in that are somewhat fact specific. So we will certainly follow up with you after this presentation to make sure that you get the answer that you're looking for. David, I want to thank you so much for taking the time to join us and share with us your knowledge about the ERA environment, best practices, takeaways, and so forth. Any final thoughts as we wrap up here?
Start working on your AML programs, because that's coming up fairly soon.
Absolutely. Great advice. Great takeaway. Thank you, everyone who is in the audience and who has attended this presentation. Just as a reminder, in our webinar series, our next webinar is going to tackle the topic of cyber, AI, and Reg SP, another rule and regulation that's coming into effect at the end of this year and into next year. So again, AML and cyber, the two big rules that firms are tackling this year. David, thank you again for your time. To the audience, thank you again for tuning in, and have a great day. Thank you, everyone.
Thank you. Thank you very much.